Order. And let's stand and do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Due to Chairman Bell's, she had surgery and she informed me that she wouldn't be here today, so I am filling in as the chair for the first time. I've never sat away from Rick Rogers, and anyway. But let me read the city's accommodations. And this is, the city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should, at least 48 hours prior to the meeting, submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings and, for such purpose, may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented in the to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the board at the time their case or agenda item comes before the board hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Okay. Next, would like to swear in any witnesses.
Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth? Thank you.
Okay. We all received the minutes in the meeting. We all received the minutes for the last meeting in the mail, and I hope you've had a chance to review them. Are there any questions or corrections or anything?
I actually have not received any minutes.
Didn't receive the minutes.
I did.
Okay. Several members did not receive the minutes.
If I may, Ms. Chair, the board has a choice. You can proceed with, if there's 4 members that feel ready to proceed with approval of minutes. If you don't have 4 members ready to proceed with approval of minutes because of inability to read them in advance, you can defer approval of last month's meeting minutes until the next meeting. So we can do it now if you've got 4 people ready to do it. If you don't.
Do we do it as a roll call vote?
Yes, that will be a roll call vote. How many board members are ready to approve the minutes of the last board meeting by show of hands?
4.
If you wish, Ms. Chair, if you want to request roll call on that basis, that will be an adequate quorum to approve the minutes.
Okay, we will accept that as a quorum to approve the minutes. Do I have a motion?
I move we approve the minutes of March 12th.
Second.
Okay, we have a motion and a second. Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
No.
Member Herman?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Beckles?
Yes. So we have a majority, and we'll accept the minutes as presented. Okay. Let us move now into the old cases.
Good afternoon, Board. I would like to request that I pull an item out of order for this afternoon to be heard first, as there's a member of the audience who I do not wish to have to sit through the balance of the agenda until we get to case number 18-63 on your agenda for the property located at what is printed at 12 or 20 North Washington Avenue. Has been determined that the property is in fact 20 North Washington Avenue that the city is proceeding against.
Did you say 1863?
The case is number 18-63
Okay.
for the defendant James D. Hauk.
Okay.
It's on page 7.
That's correct. It's the
They're not all in numerical order. Okay, on page 7. Everybody got it? Okay.
If everyone's found where we are with this agenda item, the code enforcement officer that is here to present testimony on the notice and the procedural documents is Officer Lewis. I'd like to invite him up to go over those notices, and I also have invited the building official, Gary Stepalovich, to provide additional testimony regarding the nature of this violation, which is 656 permit required regarding a billboard. But I'll first go over the nuts and bolts of this case with Officer Lewis, if you would join me. This is new business, a case that has not been heard before. Officer Lewis, did you have an opportunity to inspect the premises at 20 North Washington Avenue?
Yes, I did.
And when was your first inspection?
October 6, 2017.
And did you find this property in violation of the Titusville Code of Ordinances?
Yes,
How did this case come to you?
by a staff member.
And what department sent this case over to you? Okay. What was the nature of the violation that was cited when you visited this property?
Chapter 6-56, work without a permit.
Okay. Did you provide notice of the violation to the owner of record by first class and certified mail, as well as posting the same on the property?
Yes,
And at City Hall?
yes,
And do you have the proof of mailing and an affidavit attesting to this notice?
I do.
Can you please submit the proof of mailing and affidavit as to notice into evidence as Exhibit Number 1? And did you do a subsequent inspection to determine if the property was in compliance with the violations as cited?
Yes.
And when was your follow-up inspection?
March the 28th, 2018.
And based upon your inspection, did you file a complaint?
Yes, I did.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail, posting the same on the property and at City Hall?
Yes, I did.
And do you have an affidavit as to this notice?
I do.
Please place a proof of notice and affidavit into evidence. It's Exhibit Number 2. And for the third piece of evidence, do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes.
And what is the amount?
$358.05.
Thank you. Please submit that into evidence as Exhibit Number 3. Thank you, Officer Lewis. Before I invite up the building official, I'd like to submit Exhibit Number 4 into evidence, which is an affidavit that was prepared that I will read into the record. It was prepared by Number 1 states, I am the senior planner for the city of Titusville, Florida. This was written by Trevor Traphagen. And Number 2, this affidavit is made from his own personal knowledge. Number 3, that on Tuesday, September 12th, 2017, following Hurricane Irma, I viewed the billboard sign between the properties located at 12 North Washington Avenue, the KFC restaurant, and 20 North Washington Avenue in Titusville, laying in the parking area on the property at 20 North Washington Avenue. Number 4, the poles serving as structural support appeared to have broken during the storm and the billboard sign and structure were laying on the ground horizontally. The portion of the poles closest to the ground, less than approximately 24 inches, remained in the ground, but the upper portions, above approximately 24 inches, were broken as the structure of the sign supports failed. And it is signed by Trevor Trapphagen. I will enter this into evidence.
Do we have any photographs?
I would like to invite the building official, Gary Stepalovich, up. He does have additional photographs and testimony and documents to submit to this board.
Good afternoon, Board. On about October 1st of last year, I received a complaint from a staff member that there's a billboard that had fallen over and it had been replaced without benefit of permit. On October 3rd, we posted the billboard as a stop work order, and on the same day we sent out a violation letter.
Would you like to put this photograph on the overhead?
Sure.
Okay.
Go ahead. I don't know if you'll probably won't be able to see it too well. We could probably pass it around.
This first photograph that I'm going to submit is a photograph of the stop work order that was posted.
We have the photographic evidence.
Before you proceed,
Okay.
Gary, do you know when that photograph was taken or when that stop work order was posted on the property?
Yes, it was posted October 3rd, 2017.
Thank you.
We have photographic evidence from January 2017 of the original billboard in place, which I have a photo of it right here. On September 14th, we have a photo of the missing billboard. We never were able to get an actual physical photo of the billboard laying on the ground, but we have a Hurricane Irma photo from overhead showing the billboard missing and the structural parts laying on the side getting ready to be rebuilt.
Let's put that on the overhead. Were these photographs obtained from the Brevard County Property Appraiser's website?
Yes, they were. As you can see,
And can you show the photograph from before the storm?
let's do that first off. Here's the January 2017 photo.
Can you point where that billboard is?
That's where the billboard is, right there,
And the shadow you can see behind it?
and there's a shadow of it right there. All right. On September 14th, when they did the flyover, you'll see, well, it's difficult to see, but there is no billboard through here at all. Over here, you'll see all the new structure parts waiting to be installed. Here's another photo of these parts. Again, you can't really see well, but these are all these structural parts waiting, and again, the billboard is not there at all. It had been removed at that point. This photo was taken January 9th, 2018, and you can see there's the new billboard that was erected in the same spot as the one that had blown over. And that was pretty good.
In October, after the city issued, I'd like to enter these photographs that are each date stamped as of the date that the property appraiser recorded them into evidence.
So all of these photos are from the property appraiser's website?
Yes, sir. And they are available as of today. Now they've gotten a better program to look at the photos.
After the city issued a stop work order on October 3rd, did you receive any communication from an owner or representative of the property?
I did. I received an application from the owner well, we had a conversation prior to the submittal of an application, but we received the actual permit application for a new billboard on November 28th, 2017.
I'd like to enter the application into evidence.
And with that, you'll also see the proposed site plan of the the location.
And that's slow down a little bit, Chelsea, there's gonna be more election process.
Can you, as the board attorney is going over these evidence items,
The date of the photographs, not, I'm getting inaccurate dates. You're indicating the date that came from the website and then the photographs themselves
I'm sorry.
Let me catch up with you, and then I'll
Okay.
restate what you presented into evidence. I have received into evidence 2 photographs that appear to be dated September the 14th, 2017. I presume those to be the 2 photos you made reference to.
Microphone.
Those are the 2 photos I made reference to that show that the billboard,
Gary, if you don't mind, why don't you say them again with the right dates and tell me what these photographs depict with the photographs 2 at a time, because you've got 2 of photographs on the same date.
we'll get that squared away. The first one I'm going to give you is dated, it was a flyover from January 10th, 2017, from Brevard County. That is depicting the original billboard as it stood.
There are 2 photographs from January 10th showing 2 angles of that same billboard. 2 photographs from January 10th, 2017, showing a billboard that was deemed by the city to be non-conforming, which is part of the issue with this case, is that the billboard is non-conforming and once destroyed cannot be rebuilt without a permit. And the permit that was applied for was later, I'll get into further detail, but this billboard that you're seeing in January 10th, 2017, the first 2 photos are the non-conforming billboard prior to Hurricane Irma.
The next 2 photos I'm going to present to you were the flyover from September 14th, 2014.
17.
I'm sorry, September 14th, 2017, showing the lack of a billboard in place and the placement of new construction materials on the side for, I guess, a proposed billboard. And the last 2 photos I'm going to present to you are photos taken from the flyover on January 9th, 2018, indicating the new billboard being in place. And January 30th, also, I'm sorry, this is January 9th, 2018, and January 30th, 2018, showing the new billboard in place. Sorry.
Thank you.
All right,
The
so
document that was last provided to the board attorney was an application for a permit for a sign that was erected after the city had issued a stop work order on October 3rd. This application was received by the city on November 28th, 2017. Gary, what was the city's response to this application?
on November 29th, 2017, it started the review process, and it was denied at that time there by Mandy Lamoth, our development services manager. And the reason for the denial was the existing billboard was destroyed by Hurricane Irma. Per section 28-102, billboards are not allowed in the DMU zoning district. Therefore, the billboard cannot be re-erected. And that's her comment on our Citizen Serve account right there.
Thank you. I can submit the Citizen Serve screenshot to the board for their review and into the record as additional evidence.
And approximately 5 days later, apparently there was communication between Mr. Houck and my building plans manager, Paul Ballington, And in this email, it was stating again to Mr. Houck that the reason why the permit was denied for the billboard. And it goes into the details for a DMU district and not being allowed to be rebuilt.
Because this email contains the code section that talks about the requirements for a non-conforming sign, I'd like to also submit this email into the record, which was sent December 4th, 2017.
What is it? Sorry. What is it? D&E district?
The DMU down,
The downtown mixed use is the zoning area that this property is located in.
that's basically our downtown South Washington, Hopkins, where the new gas station is going, the Kentucky Fried Chicken, all that general area east of the railroad tracks pretty much. Yeah, it goes a little bit beyond, but
And what they're saying is no billboards are being allowed in that area.
that's correct. That's what our zoning requirement.
When
states
was it rezoned?
That was in 1996, 1998 approximately. There's actually a notice on in our records showing that the owner had received notification that billboards are no longer, that they were non-conforming.
And this particular one has been up in good standing since 1995.
That's
the one that fell.
That's about the correct dates, yes.
So there's nothing with grandfathered in because once it's gone, if it's standing there, it's okay.
That's
But
correct.
once it's gone, you
That's
can't
it.
put anything else up there. Thank you.
Yes, sir.
It's my opinion that there's no question that this billboard was removed at some point during the hurricane, and then the owner of the property came to the property and spent probably a substantial sum in order to replace that billboard. But at no point until that billboard was re-erected did they come to the city to ask for permission. And the code case that's before you today is 656 for a permit being required. There is a sign that was erected, a large physical structure that was erected without a permit from the city of Titusville. And the building official is here to provide testimony and answer your questions regarding the process that a property owner would follow to get a permit for a sign of this nature. In this case, a permit could not be issued because it's not allowed in the zoning area that this property is located in. The property owner did not obtain a permit and cannot obtain a permit for this billboard, and the resolution of this matter is bringing that sign down. I have the owner of the property sitting behind me, and he would like to present his side of the case to you, but I'd like to first make sure this board understands all of the issues and see if you have any questions that we can answer.
Was the board completely erected by 10-3?
Yes, it was.
So all the work was finished, but you still issued a stop work?
Yes, and then that's the normal procedure. Even though the work may appear to be finished, we still have to post it as a stop work order.
And what's the legality there, Rick Rogers,
As to what?
as to if the job is completed prior to a stop work order, what obligations the property owner has in compliance?
Obviously, the stop work order says no more work can be done on site is the purpose of the stop work order. That is apparent city procedure that they choose to post a stop work order even though it appears that the work has been completed. They did not receive a permit, so they don't know how much work is intended to be completed. So as a matter of caution, they post a stop work order to say, like when we were little kids, freeze tag, stop. Don't do anything else on this site relative to that improvement or change in the property.
So this board's interest is compliance, and in order for him to comply, he'll have to demolish the structure. And so if it was completed prior to his stop work order, does that prevent any of those?
What appears from the testimony that is being presented is that a billboard was allegedly erected without the required permit. So anytime there are improvements or changes to property in the city of Titusville without a permit, that's why you have to have a permit to make sure that the proposed change or improvement will meet code in and of itself, is to be placed in proper zoning. A lot of rules have to be met to obtain the permit in the first place. So if no permit was obtained, it would appear that a billboard was erected inappropriately, And that's why it's before this board, is the city is requesting the board to find that those facts occurred and that there was a violation of the ordinance requiring the permit. The resolution obviously would be to remove the violating structure to achieve code compliance. Unless the defendant has some other remedy he can resolve with the city of Titusville. City administration has a lot of latitude in the city. That's up to the defendant and the city staff to determine if there are any other alternatives other than removal of the structure.
And I assume that had the owner of the billboard put in for a permit, he would have been informed at that time that it wouldn't have happened anyway.
That is correct. Because of the zoning regulation prohibiting that, that's correct.
Thank you.
Oh, so 50% of its current value. So that's why we went into the 2 foot of the pole originally and things like that. So we're saying that the reconstruction exceeded 50% of the current value of the sign. So it actually has a different stipulation. It could have only done 25% damage and he would have had the ability to reconstruct.
That would be considered a repair at that point
If it
there,
wasn't
yes.
in that zone.
Actually, this says that it has to be 50% of the current value. So if it lost 25% of value, he could repair and leave it.
That's correct. That's the way the code is written. But because it also says in there, when it has fallen.
There's a language that talks about it being severed.
Right.
Okay, severed or lifted from its foundation.
Does the board have any further questions of staff? I'd like to turn it over to Mr. Hauk to provide his testimony. Thank you, Gary.
Mr.
You have to be
Howard,
sworn.
I apologize for
Certainly.
interrupting, if you don't
Certainly.
mind. Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
I do.
And your name, sir, for the record,
James D. Houck.
and your relationship to this property. Are you the owner of the property?
I am.
Mr. Houck, please proceed. Direct your comments directly to the board. I don't count. I'm just the attorney. I don't vote.
I waited for a long time to hear that. I'm probably as antsy as you are. It's okay. There's points of law and there's procedures. Your lives are important, and I don't think we want to bicker about items of the code. Even if it was 25%, it's a non-conforming board. It could not be rebuilt, now that I understand and examine the situation. Let me tell you a little bit of who I am. I'm a fifth-generation Floridian. The first hurricane I recall is Hurricane Donna, about 1960. Whenever hurricanes come through, you hunker down, and then you get up the next morning, you fix what's broke. The sign was broke, I fixed it. That's how and why that got done. I'm not a company. I have 2 boards. That's one of them. The other one's up in DeLand, where I live. The board was, as far as I know, originally built in 1963, to answer your question. There is a Royal Castle hamburger place at 20 North Washington that was built that day. I inherited the board when I bought the property in 2000. Mr. Grant had passed away. His daughters wanted to sell it. They liquidated it. I bought it because it was contiguous with the piece, because I had the KFC. That's what I really do. I worked 7 years with the city of Titusville to build that KFC. It's in the historical district, or was at that time before you changed the designations. I went before several boards and pleaded a case to improve that area, because the original building was from the 50s and was a drive-in structure. Kurt James, I guess, one of the Kurt Realty, owned the rights to the board on a 50-year lease, which was not made public to me when I purchased the property. Anyway, in about 2012, the board was in such disrepair that DOT wanted to take it down. It was a bad situation. I had sent certified to Mr. Kurt that the pieces were actually falling on my building, and the city was not involved at that time. So code enforcement has gotten much more stringent, and you guys are doing a good job. I resolved that with DOT. We fixed the board. We put it in current requirements and statutes that would make it usable, because it was vacant for probably 3 years, maybe more at that stretch. And that was one of the complaints from DOT. So I improved the situation at that time. I got it usable, got to advertise some of the businesses that are taxed in Titusville. The board is non-conforming, and it's in a position that nobody wants it. I got that. What I do have is $23,716 approximate dollars to re-erect it because it was down. I never saw it, so I can't tell you truthfully what it was, whether it was broke off or not. I have pictures of the structure, and I don't think they were new pieces that the picture displaces. I think they're pieces of the old one that we reused. But they were sawed off, the were sawed off, and they came back and plucked those right out of the ground and put the new poles right in. So it was in the same area, and that was one of my directions to them, was don't go monkeying with anything. Pull the same number of poles out, put the same number of poles in, put them right in the same hole, and make it as useful and code-worthy as it was prior to that. That was done. That's about all of the jabber I guess I need to throw at you. I have talked with Mr. Broom. I've talked with Mr. Farrell. I've talked with Mr. Ballinger. I've talked with Tim Ford. No, not actually talked to him. We just swapped voicemails. At my trips down here, it was a little misleading. As a criticism, I guess I'm wringing my hands. I was encouraged to file a notice of commencement and proceed toward a building permit in November, and I couldn't get that. So when I got back and got the communications, I believe that December was one of the dates of communications, that no, there could not be, and it should not be. So the ball was sort of in your court, and that's why we're here. What I'm asking for is time to recoup some of my expenses and then take the board down. I'm not going to buck the city. The ordinances are very clear. It's a non-conforming. And the best part is we finally got some development on that end of town instead of a dead and dying area, a blight-ridden area that I've been paying taxes on for a long time. Cumberland Farms should be a really nice piece. Open your gateway. I have, like I said, the Royal Castle. We used to call it Royal Castle Steakhouse, but I was stretching it a little. Building that needs to come down. If you grant me an extension to be able to work on this, I will put my efforts to take that down. Later in this year, we come back into hurricane season. Believe that or not, it's only about 6 weeks away. If there's any damage, of course, it will come down and this proceeding will be moved. But I intend to improve the area. Right now, the board is not a blight, is not a problem. It's just not conforming. So I ask for leniency and that you give me some time to be able to recoup some of the expenses, $23,000 that I spent to repair that, and it ain't going to be free to take it down. So I guess
much
that's my
time?
case. Sorry?
How much time?
Well, my recommendation is November. That'll give me 6 months to see. I don't even know what the board produces. I use Lamar billboards to manage it, and they only report to me every 6 months. So I don't know how far in the hole I am or out of the hole I am. In November, I will be prepared to review that and give you a time certain. And in that meantime, I'll be working to demolish the building that is not a good situation. So I won't be just counting my millions of dollars, haha.
I'm less familiar with commercial real estate, but in residential real estate, usually when they do the title search, they will inform you of any structures that are of non-conforming use. And if you bought this property in 2000, did your title company do anything like that?
Make that known to me? No, I did not involve myself with the board because it was on a 50-year lease. Even in 2000, it was still, what is that? 2013, I guess, was the end of the lease, and that was 13 years hence. It really was not a point of my attention at that time. It was between two pieces of property. It was on a lease that would refer to the northerly piece, so then I could combine all of the pieces to make a usable piece of property for Titusville. I think I'm through.
Any other questions?
Are you saying, sir, that you had no knowledge that this billboard could be replaced or could not be replaced?
There was testimony that there was something sent in '96. I don't recall it.
But you weren't the owner in 96.
No, I wasn't. I wasn't involved with it in '96. So I don't know that I even got that.
So you weren't aware that you were violating an ordinance by replacing the billboard? Is that what you're saying?
No, I knew that I would probably need a building permit because there'd been a hurricane through here. Y'all were pretty much underwater as far as building permits.
Yeah.
If you issued every one that you should have. And I knew that I wasn't going anywhere, and the board was there, and we'd eventually get around to settling up.
So what you're looking for is like a 7-month continuance on this, and at about November, you would take down this billboard to bring the property into compliance. Our main purpose is to get property into compliance. I don't know how the city would stand on this, and the building department would stand with giving you a 7 months continuum. We're here to enforce the letter of the law, and that's saying, my personal opinion, not with the board, you're in violation by erecting that sign. Therefore, I would have to vote yes that you were in violation of it. But also, I'd like to see the property come under compliance by you removing the billboard. Now, if the city and the building inspectors say, we can work with this, I have no problem with giving you a continuance on it. And I'm sure the rest of the board would, but that's the question that we'll ask the city.
Okay. Well, I have, like I say, I gave you the list of folks that I have talked with down here since October. And all have been very cordial And once this board was engaged, there has been no offer of any direction or alternative, or as you said, any other remedies. So I am sort of out in the cold here, as I was in November when I was told that I didn't have a permit, so I went and applied for one and filed a notice of commencement, which is not just filling out a paper, it's a process. I didn't get the rest of the story, if you will. Nobody seems to want to hold this hot potato. I'm not contesting that it's a non-conforming sign. I'm not contesting that it's up without a building permit. And I agree that I will take it down. I think that is in the best interest of the city. And I ask that you, in my best interest, allow me to rent it for a little while so that I can recoup some of the money I got in it and the money I'm going to have to pay to take it down.
If Ed makes that motion, I'd be prepared to second it, but we just want to make sure that you understand that by the time we get here to the November meeting, if it's still out of compliance, that's when we would assess things. So by the second Monday in November is when this board would be interested to see it come into compliance.
Second Monday in November.
This hasn't been established yet.
No, I said if Ed made the motion, I would second it, but I want to make sure that we all understand that if it's not in compliance in
That would be
November,
November the 12th.
the letter of the law means that that's where we start to impose.
For clarity, at this point in the discussion, Mr. Howe, the board has limited jurisdiction. They listen to the evidence presented, and you have honorably acknowledged, you acknowledge your sign is in violation of being up without a permit. Is that correct?
Correct.
Well, then it's a given. There is a code violation. Level 2 for this board is to determine what is necessary to achieve code compliance in a balanced way. You've made your request of the board. Now the board needs to hear from the city as to how they respond to your request, as before the board can determine what is a reasonable period for you to achieve code compliance. So what says the city?
As I stated at the beginning of this case, I believe that there's no question that there's a finding of a violation here. And the city requests that this board make that finding of fact that there is a violation, that there was no permit for the billboard that was erected in October 2017. Regardless of the communications that happened in November, a application was not granted because it is not allowed to erect a new billboard in the DMU where this property is located. So if this board thinks that it's appropriate to wait to see if November is the right time to take it down, that would be acceptable to the city. It's been 6 months already since the hurricane, and we've been trying to work with the property owner to figure out if there is any alternative, and it is apparent that the code does not allow any flexibility. You cannot have a variance for this type of use. And so there is no other solution that we've been able to come up with, which is why it's taken 6 months to bring this case before the board. Here we are in April, and again, if this board makes a finding of fact that the owner has until November to correct the violation, that would be acceptable.
The city has indicated the board can retain its discretion to determine a reasonable period to achieve code compliance.
For the record, 6 months is October. November is the 7th month from today.
November was what I asked for, sir.
That's 7 months.
Because that will give us the time then to accumulate the financial data from the past half year and be able to see where I am.
Procedurally, the board needs to follow its normal practice, and a motion to determine whether or not the evidence presented warrants a finding of violation of building without a permit. And then your level 2 is a reasonable period to achieve code compliance.
I'm prepared to make a motion.
You can, this is a somewhat unique circumstance for the board, so to give a little bit more guidance as to alternatives, you can give a reasonable period, you can find violation, you can indicate now what the fine will be if compliance is not achieved by a date certain you determine. So you can predetermine the amount of the fine now, or you can do what you normally do, say you've got a reasonable period to achieve code compliance. If you stretch that out to some time down the road, 6-7 months down, and compliance is not achieved by the date given, then the board would have to rehear the matter to determine a reasonable punitive fine to compel immediate code compliance. So you can impose fine now, or you can wait until later if the board is inclined to grant the defendant's request for an additional period to achieve code compliance by removal of the billboard.
Okay, so we've heard the testimony from the city and from Mr. Hauk, and from the attorney. So do we have a motion?
I have one more question. Mr. Howe, would you be able to have that sign removed if any hurricanes come through, don't do it for us, by November the 12th?
Yes, sir.
Okay, I'm going to hold you to that.
I told you, so I got to do it now or die.
Yes, sir, thank you.
Officer and a gentleman.
Okay, motion?
Okay.
I'll make motion. Move that the board issue the following findings of facts in case number 18-63 relating to the defendant, James Hauk. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner or is in possession of the real property located at 20 North Washington Avenue, Titusville, Florida. The defendant is in violation of the following provisions of Code of Ordinances of the City of Titusville, Section 6-56, permit required.
Is there a second?
Second.
Okay, so, pardon me? Oh, I was going to say it's been properly moved and seconded, and we can have a roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Vice Chairman Beckles?
Yes. Okay, so,
Second motion. I move that the board issue its order to correct relating to the defendant, James Hauk, adjudging the defendant to be in violation of the section of Code and Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9 a.m. on November the 12th, 2018 to correct the violations to the written satisfaction of the code enforcement officer, or to appear before this board at City Hall, Titusville, Florida on November the 12th, 2018 to show why the violation has not been corrected and why this board should not proceed to impose a fine for the violations.
If I may make a minor interruption before there's a vote, we had talked about setting the order to correct the Friday before, and
Oh, you're right.
Yeah.
and
okay.
if you could adjust that date.
Absolutely, I will. So that would be November the 9th,
Second.
2018.
Second.
The defendant is ordered to pay $358.05, which represents the cost incurred by the City of Titusville to bring this case before the board.
your second still stands? Okay, so it's been properly moved and seconded. Is there any discussion? Okay, roll call vote, please.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes. Okay, so you will be hearing from from the city attorney with a summary of what the judgment is here, and is that it?
If I may, Ms.
Go
Chair,
ahead, go ahead.
Mr. House, you will receive a written decision of the board in about 10 days to 2 weeks to your address, 109 West Vermont Avenue, DeLand, Florida, 32720, correct?
Correct.
Do you have any other questions regarding the decision of the board?
Not at this time.
Okay. If you have follow-up questions, you may want to contact the city attorney's office. I'm the attorney for the code board, so I stand neutral, as does the board. If no other questions, we appreciate your attendance.
Thank you, ladies and gentlemen. We appreciate your work. This is how cities go forward.
All right, thank you. Okay, I guess we'll be going back to the beginning on page 2. Old cases.
The first case listed under old cases is number 17-128 for the property located at 1517 Elm Terrace in Titusville. I'd like to amend the name of the defendant in this case, board attorney. I've gone on to the public record and determined that we have misspelled her name. She has, I believe, gotten good service, and I don't think there's any question of that. We saw her at previous meetings, and I'll give you an update on the case, but her name is spelled Jenifer. There's one N in her first name, and her last name is Gogan, Geoghean.
And I think it's Gagan.
Gagan, thank you.
Geoghean.
Ean.
And she's Jennifer with one N, middle initial E stays.
Yes, sir.
Thank you.
Thank you.
Hearing no objection, I'll add that to the next decision of the board to indicate that the name of the defendant has been corrected due to a typographical error
Thank
in
you, sir.
spelling.
As this board is aware, this case is regarding a fence that was constructed without a permit. The permit that the applicant for this property had issued was issued on July 19th, 2017. After that time, this code case was created, and after that time, the owner of the property submitted an application to the Board of Adjustments and Appeals for a variance to allow her 6-foot-high fence where it has a restriction of only being 4 feet tall in the front yard setback. Ms. Gagan was granted her variance in part, and it was denied in part. And so the owner of the property has also been given notification from the building official that she has got an additional 60 days to make those changes to her fence that's in place because she needs to modify what's existing. The building official wrote her an email giving her until June 5th, allowing her that time to correct the fence. The front portion, that front yard, needs to be at 4 feet, and the Board of Adjustments and Appeals allowed the corner to step up to 5 feet for a 4-foot section from that corner so that it is not 6 on 4 feet at that corner. It's a 5-foot corner in height. And then after 4 feet in depth on the side, the fence can continue at 6 feet tall. So that's the permit that was granted by the variance board. Ms. Gagan needs to contact the building department for a final inspection prior to June 5th in order for that permit to be closed out by the building department. And so I'm hopeful that that will happen prior to your June board meeting. And I would request now that this board continue this case until that meeting.
Second.
And would that be the Friday before that you're giving her a deadline of?
June the 8th, 2018.
Thank you.
As I recall this case, the lot was originally, had 2 dwellings on the lot, and the lot ended up splitting in half. And she was on what was the rear portion, is that right?
Yes, that's correct.
Okay. The rear was on Elm Terrace, but it's now the front.
Her front yard is Elm Terrace.
Okay.
Okay, so it was moved by Edens and seconded by
The rest of them.
whoever. Okay. All right, any other discussion?
Yes. Continued until when?
Our meeting is June the 11th, but we're asking for compliance by June the 8th, the Friday before the meetings.
Well, didn't you say June 5th, the city gave her to June 5th to make the corrections?
Well, to close out the permit. The city gave her till June 5th to close out the permit.
Okay. So is it appropriate for a June 5th, Attorney Rogers?
Bear with me just one
Okay.
moment. So before I hear your question, I understand the city requested a change to the compliance date to June 5th?
No.
No, okay, the city is giving Ms. Gagan till June 5th to close out the permit, but in the motion, they said on June 8th for the order to correct. So should those two dates be the same?
No, the defendant's requirements to comply with the partial variance granting by BAA is between the defendant and BAA. I would recommend to the board that, I understand what you're saying now, that the board's to acquiesce in what has happened outside the board's purview, that the city is now requesting the compliance date for code enforcement be changed to June the 8th, which is the Friday before our code board meeting on June the 11th, correct?
No later than June 8th. If June 5th was the decision of this board, that would also make sense and be an appropriate deadline for the correction, because that is the building permit deadline.
Although because it's a second read, we have the ability to go back and do retro fines anyway, correct? So why would it matter?
It depends on what your order to correct date is.
Yes, because you can only do retroactive fines back to the date set for compliance. And it's my understanding that we're now discussing changing the previous date set for compliance to a later date due to partial variance approval.
Okay.
So I think we're about at the same place, but am I hearing more requests other than compliance date to June the 8th? And if compliance is not achieved by that date, the defendant shall appear on June the 11th to show cause why a fine of up to $250 per day should not be imposed as of the compliance date, June 8th. Is that adequate?
Yes.
Well, with the motion maker and the motion seconder and the board.
My motion stands.
Okay,
And I second.
thank you. I have no further questions.
Okay. All right, so it's been properly moved and seconded. Can we have a roll call vote, please?
Member Herman?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Vice Chairman Beckles?
No. Okay, so the motion carries. So she'll have until June 8th per the Code Enforcement Board to correct the situation. Okay, next case.
Thank you. The next case is number 18-25 for the property located at 201 Robbins Avenue in Titusville. This case was previously continued, and again, the city wishes to continue this matter for 1 month as the application has been received and the owner has submitted most of the required documents. We are anticipating your next code board meeting.
So moved.
Second. Okay, it's been moved by Edens and seconded by Richardson. Is there any discussion?
For clarity to the board attorney, what is the deadline that you are setting? Is it Friday at noon?
Yes.
If I may make sure I'm on the same page with everyone else, we are on case 1825.
Yes.
The last decision of the board was effectively a continuance. There has been no findings of fact in this case, so the city's request for a 1-month continuance, I heard there was a second granted, no roll call yet. What is my question, if any?
I asked if there was a deadline, and it's inappropriate. This case is continued to Monday, the code board hearing. Thank you.
Thank you.
The next case, the next item is roll call. Sorry, Gina.
Okay. So let's have a roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes. Okay, so this case will be continued for 1 month. Okay, the next case?
The next case, number 18-29, for the property located 4170 Barna Avenue, has the same disposition as the case you just heard. This case was continued by this board at your last month's hearing, and I again request that this case will be continued.
Moved.
Okay, so this case has been properly moved and seconded. Is there any discussion? Roll call vote, please.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Herman?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes. Okay.
For case number 18-30, the city wishes to withdraw this matter as the BTR has been issued and the case is in compliance.
Okay.
No motion for that, right? Do you need a
We
motion to
don't have
withdraw?
No, and that there was no decision of the board previously in case number 18-30, city's indication that they wish to withdraw the complaint. There is no requirement of the board. The city, in their discretion, can always withdraw a complaint they present to the board before you adjudicate the complaint and find violation.
Okay. Thank you. Next case.
For case number 18-36, the property located at 500 Titus Street, the city wishes to continue this matter until your next scheduled board meeting.
Motion.
So moved.
Is there a second?
Second.
Okay, it's been properly moved and seconded.
Before roll call, if I may, Ms. Chair, with the board's approval and the city attorney's approval, on the city's request for a 1-month continuance, I routinely will put within the decision of the board 1-month continuance granted to allow the defendant on an additional period to achieve code compliance.
That would be
wasn't-
appropriate for this one.
Okay, thank you.
And this one, we actually want to move that date to the Friday before because we have heard and made a decision. We've established a violation and we've assessed cost. So we're asking for the date of compliance to be the,
In effect, you have discretion in that regard. Since this case has already been heard and a finding of violation was made, your date set for compliance was April the 9th, today at 9 a.m. So the city's requesting a continuance of the case. You can just continue the case and allow your compliance date to stand.
okay.
Although rarely will the board choose to retroactively, using your term before, back to the original date set for compliance because we're giving the defendant additional time to achieve. So
Okay.
in the interest of brevity and not having a long meeting, I would just suggest if that's the inclination of the board, just grant it. And then you can deal with the issues next month, because then the city can tell you if there was a concerted effort to work towards compliance or someone might have been sitting on their hands. Then you can reconsider how far back, how much fineage you feel to be appropriate.
Thank you, sir.
Okay, so does your motion still stand?
Yeah.
Okay. All right. Any other discussion? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Vice Chairman Beckles?
Yes, so the motion carries. Okay, next case.
The next case, number 18-39, for the properties located at 514 LM Davie and 516 LM Davie Lane, is being withdrawn from your agenda by the city as no permit is required for this matter.
Okay.
The next case, number 18-41, for the property located at 2075 Cathy Circle, is being withdrawn due to compliance.
Okay. Next case.
The next case on your agenda is 18-45 for the property located at tax ID 2218027 on Grissom Parkway, which is at the corner of Grissom and Meadowlark. I have Officer Crisco here to provide subsequent testimony, as this case was previously presented to this board last month on March 12, 2018, and the board ordered the owner to correct the violations by 9 a.m. today and to pay the cost in the amount of $340.44. Officer Crisco, have you inspected the premises at tax ID 2218027 to determine whether the owner has brought the property into compliance?
Yes, I did this morning.
Is the property still in violation?
It's still in violation.
And what violations still exist on this property?
1326 overgrowth and section 30-137, structures within the easement.
Have you had any communication with the owner or representative of the owner regarding the correction of these violations?
Yes.
And what was the nature of your conversation?
On 12/28/17, I discussed with Denise, the property manager of the trustee, explained the violation because I know her. There's been 2 or 3 violations on the same property. And on 2/9/18, I met with Evan, the property manager, along with a city contractor, and explained what had to be done to correct the violations. And I guess he assumed that not assumes the wrong word, the contractor gave him an estimate to clean everything up. And I guess.
Do you know when the estimate was provided?
At the same day, because I was there on
Okay.
February 9th.
Okay.
He talked with him over the phone. And I guess he thought it was too high, and it's still in violation.
Does the board have any questions for staff? Thank you, Officer Crisco.
I'll make a motion.
Any other questions? Okay.
I move that the board issue the following findings of fact in case number 18-45 relating to the defendant Shack Family Holding Company, LLC. The defendant continued to be in violation of the following sections of the Code of Ordinance in the City of Titusville on April the 9th, 2018, section 13-26 and section 30-137.
Second.
Okay, we have a motion and a second. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Vice Chairman Beckles?
Yes. Okay.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Shack Family Holding Company, LLC, based on the findings of fact issued this date, and that the judgment contains the following provisions. The defendant is assessed in order to pay a fine of $75 per day for each code section violation. The fine shall commence on April the 9th, 2018, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second.
Second. So it's been properly moved and seconded. Is there any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Vice Chairman Beckles?
Yes. Okay. All right, next case.
The next case is number 18-47 for the property located at 4590 Rose Hill Avenue. And again, Officer Crisco is here to provide testimony regarding the continued violations. This case was originally heard by the Code Enforcement Board in March 12, 2018, and the board ordered the owner to correct the violations by 9 a.m. today and to pay the cost in the amount of $375.66. Officer Crisco, have you re-inspected the premises at 4590 Rose Hill Avenue?
Yes, I did.
And is the property still in violation?
I inspected it this morning, and it's still in violation.
What violations still exist?
Section 1223, junk and debris, and section 1326, overgrowth.
Thank you. Does the board have any questions of staff?
Is the owner an occupant?
Don't know.
Any communication with the owner at all?
I'm sorry?
Has there been any communication with the residents or the owner of the property?
No.
Does it appear vacant?
Can't answer that, I don't know.
Okay.
Can't verify that, that's the right terminology.
Any other questions? Do I have a motion?
Do you know if he's deceased?
I don't have any knowledge of whether it is. Actually, the only other piece of information I can give you is that there was a Liz Pendens filed foreclosure on March 28th, which came after this case was presented last to you. I felt it was appropriate to continue and get the final judgment since we've already gotten this far with this case. Depending the outcome of the foreclosure, will probably get wiped out, but we're here, so.
Okay,
Okay, do we have a motion?
I'll make a motion.
Okay.
I move that the board issue the following findings of fact in case number 18-47 relating to the defendant Stephen Edward Rayburn. The defendant continued to be in violation of the following sections of the Code of Ordinances of the City of Titusville on April the 9th, 2018, Section 1223, junk and debris, and Section 1326, overgrowth.
Second.
And so we have Edens with the motion and Ed with the second. Roll call vote. Well, is there any discussion? Roll call vote, please.
Member Herman?
Yes.
Member Edens?
Yes.
Member Moniz? Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Vice Chairman Beckles?
Yes, so the motion carries. She did call your name, but
Sorry, I thought it was for yes.
somebody else was telling him to say yes. So anyway, okay.
Member Moniz?
Okay, all right, the motion carries, so, okay, next case.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant Stephen Edward Rayburn based on the findings of fact issued this date and the judgment containing the following provisions. The defendant is assessed and ordered to pay a fine of $75 per day for each code section violation. The fine shall commence on April the 9th, 2018, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Do we have a second?
Second.
Okay, once again, Edens and Moniz. Discussion? Okay, roll call vote, please.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Vice Chairman Beckles?
Yes. Okay, the motion carries. Now we're moving into new business, new cases. Move on.
The first item in new cases is number 18-52 for the property that's located at 616 Roderick Harris Senior Ave, Apostolic Faith Tabernacle Church Incorporated. This case is being withdrawn due to compliance as the business tax receipt has been issued.
Okay, next case.
The next case is number 18-53 for the property located at 2408 Fox Hollow Drive in Titusville. And the city requests to continue this matter as the application was received for a business tax receipt on April 5th, and it is under review.
So moved.
So moved.
How long are you asking it to?
Until your next scheduled
Just to the
board
next
meeting.
meeting. And who made the motion?
I did.
Okay, is
I'll
there a
be the
second? Okay. Edens, the second, and Moniz. Any discussion? Okay, roll call vote.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Herman?
He just
stepped
stepped
out.
out.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes, so the motion carries. Next case.
The next item is case number 18-54 for the property located at 1404 South De Leon Avenue, owned by K Family Investments. This property is being withdrawn due to compliance as the business tax receipt was picked up this morning.
Okay.
The next item on your agenda is case number 18-59 for the property located at 3478 South Hopkins Avenue, Today Nail and Spa. The city requests to continue this matter to allow for an electrical inspection that was required after the initial inspection and for 1 month until your next scheduled board meeting.
Continue. Second.
Okay, we have a motion.
Yep.
We don't have to, right?
Yes, a motion
We
to
have to
continue
do a
is
motion.
appropriate.
And Ed, you made the
Yep.
motion. Is there a second?
Second.
Okay, roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Vice Chairman Beckles?
Yes. Motion carries. Okay, the next case.
For case number 18-61, the property located at 5455 Andrea Street, the city wishes to withdraw this matter due to compliance.
Okay. And we've already done the next case, so we move on to case 1864.
For the property located at 1015 North Carpenter Road, the city wishes to continue this matter for 1 month to allow time for the property owner to achieve compliance.
So moved.
Okay, the second.
Second.
Second. Okay.
Oh, forgive me, Robbie. Okay, so it's been properly moved and seconded. Are there any questions? Is there any discussion? Okay, roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Vice Chairman Beckles?
Yes. Okay, moving on to cases not heard by the board. Alyssa, do you need a break? Does anybody want to take a break?
So this section, beginning on page 8 of your agenda, is a number of cases that are not being presented to the board. No action is required. This is informational items only. This is to show you the items that were closed out prior to publication of the agenda for the items that would be heard. Everything that's listed at this point is something that you would typically not see in your agenda, but under the new format of the agenda, you're getting this additional information to supplement the information that you get at the balance of the agenda, so you know all of the work that the department is doing. If you have any questions about any of those particular cases, you know what officer is handling it and whatnot.
I like the new agenda and the new format.
I do too.
Props to Megan. She's done a great job with it, and we appreciate it.
All right, thank you, Megan.
We're done.
No,
mean,
okay. All right, does the board attorney have a report?
No
No
report.
report. City attorney?
I have no report either.
Okay, code enforcement manager? Not
He's
here.
absent today, so
He's
there will be no report there.
Chairman's report? Any board members have a report? Well, we will adjourn this meeting.